give anybody my ID unless I've committed a crime.
So we can make it real easy or we can make it real hard. Well, all I'm asking is for your ID that I identify who you are in case.
You get a chance to talk to the people upstairs?
Who? Jesus?
No, the people upstairs. They have to give you like some type of permit to
start going to church?
Recording in there. Do you have your ID?
Excuse me?
Do you mind if it's your ID?
Let me see your ID.
So do you have your driver's license?
I just want to know what crime I'm committing.
Do you have your driver's license?
Give me your name.
Oh, bless your heart. God bless you. See, now the bad thing is for you, unfortunately for you, is I know my rights and I know the law, and I know I'm not breaking.
Or there's lots of keys, but one of the keys is the officer has to have articulable facts to begin with that meet the elements of reasonable suspicion.
Sure, and in the situations that we're talking about, I've given the example of littering, but the example doesn't matter very much.
Okay.
So long as we assume that the officer has reasonable articulable facts that would rise to reasonable articulable suspicion.
Okay, then in the context of that, the subjects that we're dealing with, in this case, the pedestrian we're dealing with, has to identify themselves.
Okay.
They do not have to produce an identification, meaning a physical driver's license or ID card. But can the officer demand that they show us one? Can they use strong language saying, give me your ID?
Yes.
Can they use strong language saying, you got a driver's license? Can they use a tone that might be perceived as more than a request?
Can they?
Yes, it happens all the time.
And that's allowed?
Absolutely, it's allowed.
Okay. And it's not until the subject says no. So let me back up. An officer, based on what I'm understanding you're saying, under HIIBEL and under NRS 171-123, an officer is allowed to use strong language of command to that the subject give a physical identification such as a driver's license. And that is not a violation of statute or HIIBEL until the subject resists or declines and the officer follows up and says, no, you have to.
Objection form.
What I'm going to say is I don't know a case or a higher judicial review that has clarified whether or not that is valid or not valid under the guise of the Fourth Amendment. The position of the Las Vegas Metropolitan Police Department is this. Officers can ask. Officers can demand. Until it's clear that the subject is clearly not going to give them a physical ID. And that has to be a very clear interaction, whether that's through communication, body language, some type of physical resistance. There has to be a clear line drawn.
Okay. And so in order for there to be a HIIBEL violation in this context of demanding a driver's license, the subject has to give a clear line of dissent or resistance, correct?
Form.
Well, you phrase the question in order for it to be a HIIBEL violation. I don't think HIIBEL addresses the context or tone with which an officer asks for identity. I think as I read HIIBEL, HIIBEL clearly suggests that officers have a right to identify a person. It doesn't have to be with a physical ID. And I don't think HIIBEL in language specifically addresses the tone and where the line is between a request versus a demand in the interaction.
Okay, and so is it fair to say that in interpreting NRS 171-123, or as we say, Terry stops or reasonable suspicion stops, you understand the context that I'm asking, correct? That I'm referring to the Terry stop statute, the exhibit.
So you're talking what we've discussed as a reasonable suspicion stop?
Right, a reasonable suspicion stop.
I apologize, I interrupted you. Sorry.
No, it's okay, don't worry. So Metro's position is that in a reasonable suspicion stop, that an officer can ask or command physical identification until the subject says no or gives a clear resistance to that ask or command. Is that correct?
I don't know that we've specifically stated one way or the other. What we teach, and this is a very, very finite point, we don't teach what isn't in the law or the case law. We don't define to officers whether they can demand or they can ask. We tell the officer the subject has to identify. And the officer has to accept a verbal identification provided they can confirm it. We don't teach the context of where that line is because we don't know.
Okay. And because you don't know where the line is, you don't teach it, correct?
We don't specifically get in the weeds that deep. Not yet.
Okay. And so, as far as Metropolitan Police Department is concerned, a police officer's demand for a driver's license is not, in context of a reasonable suspicion stop, is no different than a police officer's request for a driver's license.
I would agree with you in stating that. The department's position, whether I ask for a driver's license or ask for them to verbally identify themselves, there's no difference. And I can ask or I can demand either one. There's no contextual difference, there's no terminology difference under the guise of reasonable suspicion.
And until the subject actually resists the production of a driver's license, then there can be no violation in reference to the demand for the driver's license, correct?
Form and misstates testimony.
Again, I don't know that that's what I've said. I've said that I know you're trying to get me to a very particular point in this, and the very particular point doesn't exist based on practice, case law, or experience. The statute, and this is what we teach, says that a subject has to identify themselves under a reasonable suspicion stop. Officers can ask for identity. Officers can ask for physical forms of identity. Officers can demand identity and physical forms of identity. The subject has to identify themselves in a reasonable suspicion stop, period.
Okay. So,
Sorry, I'm going to interrupt you because I want to make sure that this is clear. We do not teach where that bright line is and how the officers approach that situation, other than there's a lot of reasonable situations based on how you might approach that to get better results, right? We teach verbal judo, we teach how to interact with people, but I'll be honest with you. In a reasonable suspicion stop, if I'm stopping somebody for a violent crime, I'm not going to be very patient in terms of asking them for identity. I'm going to demand their identity.
Sure.
But whether that is a demand and they fulfill it by verbally identifying, or I might say the phrase, "Give me your driver's license." They have the right to say back to me, "I don't have one." "No." "Okay, what's your name?" Right? It's not, there's not a bright line over this physical identity versus verbal identity. It's a flowing concept. If they refuse the physical identity, and I've asked for that, if they refuse to give me a driver's license, and I say, "Give me your driver's license," and they refuse it, "Okay, do you have an identification card? Do you have, what's your name?"
Okay.
And it automatically, it's just automatic. We automatically transfer to, okay, if it's not physical, then give me verbal.
Okay. So I'm going to give you an example, and I'd like you to tell me whether or not it would be Metropolitan's position that this is a violation of the Terry stop, reasonable suspicion stop rules. Okay. So, officer has reasonable suspicion.
Okay.
For whatever crime this is, and I don't think that it matters, officer has reasonable suspicion.
Okay.
So, is it a violation of the reasonable suspicion stop rule for the officer to detain the subject
No.
Okay. So is it a violation of the reasonable suspicion stop rule for the officer to say, "Sir, I require you to give me your driver's license"?
No.
And if the subject gives the driver's license, then there's been no violation, correct?
No violation.
And if the subject says, "I don't want to give you my driver's license," then we move on to a next phase, correct?
Let me give you some context in that a little bit.
Okay, please.
If the reasonable suspicion stop is based on him driving a car, the demand to produce a driver's license from the driver would also be acceptable.
I understand. That's why
Okay. If it's a
that's why I've put
pedestrian-
it with a pedestrian, so we're not dealing with a driver
Right.
situation.
But usually, quite honestly, with pedestrians, we generally don't ask for their driver's license. But can they? Sure.
Right. I'm not asking for general. I'm asking for the limits of what Metro's
They
position is.
absolutely. We can say, "Give me your driver's license."
Okay, and you could say, I require you to give me your driver's license, correct?
Sure.
Okay, and if the subject says no, then can the officer say, "No, I require you to give me your driver's license"?
Honestly, I don't have an opinion on that. And the reason I don't have an opinion on that is because I have yet to review any case law that gives me any insights onto court or higher judicial review related to that interaction. That's a challenge, right? The truth is we don't know where this bright line is from that perspective.
Okay, so it is Metro's position then that if the subject refuses the initial demand for physical identification, that Metro is unsure whether or not the officer can demand again for physical identification.
Well, I'm going to respond to that. So your question is, does Metro have an official position on whether or not the first interaction, the officer demands, the subject says no, can the officer demand again? What's Metro's official position on that second demand?
And specifically demand for driver's license.
Okay, specifically for driver's license or physical identification
Or
card.
physical identification card.
Okay. Metro doesn't really have an official position on that.
Okay, so if the person ultimately again says no, can the officer arrest that person for saying no?
Well,
For saying no to the demand for physical identification.
again, it's not the demand for physical identification. Remember that in training, Metro's official position is if they don't give you physical ID, they still have to ID themselves.
I understand.
We're not going to arrest them for refusing to give us a driver's license. We're going to arrest them for refusing to identify themselves.
Okay, now if the officer has not yet said identify yourself, instead the officer has said give me your driver's license, is there a distinction?
Objection to form.
Not in my mind, there's not.
Okay, so if the officer says give me your driver's license, and the person says no, and the officer then says give me your driver's license, and the person says no, but the officer never gets to give me your name, can the officer arrest the subject for refusing to give a driver's license?
Form.
I would say that in the phraseology of that question, you framed the question in a way that basically says we give two demands for a physical form of identification, and now we're going to arrest them based on the refusal to give that physical form. I have yet to see where that's occurred, to be honest with you. I don't think that's in the parameters of what we teach. I don't believe that's in the parameters of NRS 171123.
Would it be a violation of NRS 171123?
I don't have an opinion on that. I can't tell you that.
And when you say you're referring to Metro. Metro doesn't have an opinion on that, correct?
Metro doesn't teach that, right? Because we teach that second element. We tell them to go another layer, right? HIIBEL was very clear on that. It's not just a physical form of identification. Can I demand a physical form of identification from you? Sure. Can you refuse? Absolutely. Am I going to arrest you for that refusal? No.
And if you did arrest me for that refusal, would it be a violation of 171123?
Objection to form.
based on what we teach, it would be inappropriate with our teaching.
Okay. So then, let's say that the person, let's move away from physical identification and let's move to verbal identification.
Okay.
Okay. So an officer with reasonable suspicion is speaking with a subject, a pedestrian subject.
Okay.
Can that officer, so the officer then asks for identification.
Okay.
The person gives his name.
All right.
Can the officer demand more identification than just the name?
Sure, absolutely. Again, that demand is a contextual conversation, right? Demand to you might be different than demand to me. The person might be perceiving it as a demand, whereas the officer's not intending it that way. The challenge is in the context of what qualifies as a demand versus an ask.
Okay, now I am specifically referring to demand and not ask, meaning
Okay.
that a reasonable person, and let's clarify that a reasonable person would have interpreted the statement of the officer as a command.
Okay, but what is the officer's perception of that interaction? It's not, and I think this is part of the challenge with the court opinions that I've read, and the court opinions so far have refused to really take a look at this issue.
Okay, what is that issue?
And that is, where is that line for demand versus request? What is the context of identification? What does that truly mean? In the HIIBEL case, it's very clear that identification means that the subject has to either, with a physical ID or verbal identification, identify themselves. The officer has a duty to confirm, based on what they've been given, that person's identity. That is when identification occurs. In terms of the context of demand versus request versus consensual, non-consensual interactions in that space, I don't have a lot of context into where that line is. Can I demand you to give me identification? Sure. Can I demand that you verbally identify yourself? Yes. Are you required to identify yourself? Yes. It's the failure where you refuse to identify yourself where we will arrest you under NRS 171123 or HIIBEL. It's not, it's not whether I demanded or requested or the perception. It is whether or not I was able to confirm that I'm dealing with the person who identified themselves as, and that identification can be verbally or through a physical form of ID, doesn't matter.
Okay, so if a person gives their name and their name only and refuses to give anything other than their name, can the officer arrest that person?
Absolutely, provided the officer can articulate that he or she was not able to identify and confirm that subject's identity.
Okay, and so if the officer feels like that the officer needs, say, a date of birth in addition to a name, can the officer arrest for failure to get a date of birth from the subject?
Well, the question's a little complicated because it's not for refusing to give a date of birth. It's for failing to give substantial information so we can confirm identity. If it's date of birth that we need, okay, it's date of birth. It might be Social Security number 2. It might be a prior arrest or some other identifier that allows us to confirm identity. We have a right under HIIBEL and under NRS 171123 to obtain identification verbally or physically and confirm the person with whom we're dealing with under 171123 and HIIBEL.
Okay, so I'm going to hand you, are we at Exhibit 14?
15.
15. I hand you Exhibit 15. Detective we've talked a bit about HIIBEL, and you've read HIIBEL before, correct?
I have.
And I've given you an excerpt from the U.S. Supreme Court case of HIIBEL as opposed to the Nevada Supreme Court case of HIIBEL.
Okay.
Okay, and I'd like to direct you, I'd like to direct you to midway down the page where where it says in contrast. Do you see that? And I'll
okay,
here.
I got it.
In contrast, could I get you to read that, to begin reading from there?
In contrast, the Nevada Supreme Court has interpreted NRS 171123 to require only that a suspect disclose his name. The suspect is not required to provide private details about his background, but merely to state his name to an officer when a reasonable suspicion exists. As we understand it, the statute does not require a suspect to give the officer a driver's license or any other document. Provided that the suspect either states his name or communicates it to the officer by other means, a choice, we assume, that the suspect may make. The statute is satisfied and no violation occurs.
Okay. Does this refer to anything other than giving a name?
In the context of this, based on what I've just read and stated, it does not refer to anything other than giving a name. However, I will tell you, I've read the U.S. Supreme Court opinion on HIIBEL as well as the Nevada Supreme Court opinion on HIIBEL, and they expand on that a little bit more to include that the officer has a right to confirm the identity of who they're dealing with. It would be unreasonable for an officer to respond and do a reasonable suspicion stop on somebody, and I'm paraphrasing here, who has been loitering around a school grounds and only gives their name, and the officer doesn't continue an investigation to confirm identity. In fact, I believe the opinion states that the officer has a due diligence to confirm that person's identity, especially if their prior arrest history shows that they have been arrested for child molestation or other child-related crimes.
Sure, and you've given a very specific example of a somewhat inflammatory crime. It's dealing with child protection, correct?
But the context of that example is relative to our training and our decision point. It is very, very clear, based on my readings of both HIIBEL opinions, that what they're referring to is that they don't have to produce a physical form of identification. And while it does say in context only name here, I mean, as it's written, it only refers to name, it is the opinion of the Las Vegas Metropolitan Police Department that name means also enough information for us to confirm identity. Now, they don't have to tell us about prior arrests, prior background information. They do have to provide information that helps us confirm identity. That may be a date of birth, that may be a social security number.
Okay, but it's Metro's position that NRS 171123 gives police the right to demand name plus some other fact that would give the police the ability to identify that person, correct?
The some other fact is very important here. The opinion, based on what we've read here, is that they don't have to give background information. The interpretation of that from Metro's perspective, and again, I don't know another court that's ruled on this or another opinion that's ruled on this, so absent that ruling, this is our opinion. That doesn't mean they have to tell us about their criminal past. That means it has to be a piece of information that allows us to confirm who they are.
Okay.
Now, if you want to get really creative, could that confirmation be in the context, this is going to be really off the wall, but could it be in the context of give me a phone number and we can trace it that way? I don't know, maybe. But generally speaking...
Sorry, I didn't mean to interrupt, keep going.
Generally speaking, name, date of birth, social security number is adequate for our purposes.
But generally name alone is not enough, correct?
It depends.
So let's say that my name is a common name, John Smith. Some common name where there are many people of that name. A name alone is not enough, correct?
Okay, so in that context, name alone may not be enough. It may be enough. If I've had interactions with you before and I know you as John Smith and I know who you are, it might be enough. If I don't have interactions with you and you give me your name and you give me a date of birth, well, could that date of birth match similar date of birth hits on a lot of other people? Sure. So now we might need tattoo information. We might need some other piece to confirm who you are. We might even need to take you down to our jail facility and run your fingerprints to confirm. It's not as simple as here's a bright line rule and it's the date of birth and social security number and here's the name. It's a combination of factors.
Okay. So
What we teach is very clear. Officers have a duty to identify and confirm the identity of who they're dealing with in reasonable suspicion